Okay, good afternoon, everyone. Welcome to this seminar on two recent important Supreme Court cases relevant to the rights of the child. This is hosted by the Doughty Street Children's Rights Group. And for those of you who don't know that, it brings together practitioners from different practice groups aimed at providing innovative advocacy to secure the rights of children, in particular under the UNCRC. The two cases that we're going to discuss today are firstly the case of SC, in which the Supreme Court decided that the two-child limit to child tax credit is compatible with Article 14, the prohibition on discrimination. And secondly, the case of AB, I'm afraid not very memorable acronyms in both of them. AB was a decision by the Supreme Court that solitary confinement of a child in detention doesn't inevitably or automatically breach Article 3 of the European Convention on Human Rights, the prohibition on torture. Now, both of these cases are important. They were unanimous decisions. SC in particular was unanimous on behalf of 7 justices. It departs from a number of previous cases on discrimination. And in some ways, it reads as a textbook for discrimination law, at least in the context of welfare benefits. Today, we're going to have 4 talks which explore different aspects of the cases. We'll aim to have about 8 minutes or so per talk. If you'd like to ask any questions, please do put them in the chat function and we'll try to address them either as the talk goes along or at the end. The talks are by, firstly, I'm going to start, then we'll have Jamie Burton, Queen's Counsel, Shushin Liu, and finally, Professor Aoife Nolan. So my start is just an overview, an outline of the findings of the 2 cases, and we'll focus on the case of SC because it's longer. In SC, probably the most important aspect of the case was what it says about the margin of appreciation, or the manifestly without reasonable foundation test. Now, I'm sure you know, up until recently, there have been a large series of cases focusing on what the manifestly without reasonable foundation test means and when it applies, which essentially indicated that that test will apply in certain contexts. So challenges to particular types of legislation or policy, for example, controversial legislation about economic, social, moral, political issues, such as welfare benefits and so on. A challenge to any legislation or policy of that type will not succeed unless you reach this very high threshold of it being manifestly without reasonable foundation. Now, SC essentially says that's wrong. So the binary approach whereby the MWRF test applies if you're challenging a particular type of legislation or policy no longer applies. SC held that you have to look at a whole range of factors in deciding where on a spectrum the margin of appreciation lies. So whether it's a broad margin given to the state or a narrow margin, there's a whole spectrum and it depends on a whole range of factors. Those factors include the nature of the measure, so if it involves a social or controversial issue, but they also include a lot of other things, such as whether the ground of discrimination, so the status or the protected group being relied on, is a suspect ground. Is it sex, race, disability, and so on? Other factors include the impact of the measure. So how important and serious is the impact of the measure? And for example, if the impact is on the best interests of children, then that will call for a narrower margin of appreciation. Has the decision maker or parliament addressed its mind to the issue? So has it recognised the discrimination and made a decision that the discrimination was justified? And then another factor is whether there's consensus or common ground between European Convention member states on the issue. And so if you have a case now which is a challenge to one of these controversial areas like welfare benefit legislation or similar, you no longer have to hold your hands up and say, well, we're facing this incredibly high threshold and it's going to be very difficult. If you have a case where you're challenging that type of legislation, but the ground is a suspect ground, the impact of the measure is serious, it involves the best interests of children, Parliament hadn't really recognised the discrimination or addressed its mind to the problem, and many other member states take a different approach to us, then the margin of appreciation may well be much narrower. So that's margin of appreciation. It departs from a load of previous cases and it's quite a useful aspect of SC. SC also went into various other elements of the Article 14 test, so I'll quickly go through them. Ambit, often the first question, does the measure fall within the ambit of another convention right? And SC held a measure designed to facilitate or contribute to family life by supporting families with children is likely to fall within the ambit of Article 8. And that was met on the facts of the case. The next question, status, what amounts to another status? And the Supreme Court basically said you don't need to worry about this, that this rarely troubles the European Court. It needn't exist independently of another, of the difference in treatment complained of, in the sense of having some legal or other significance separate from the difference in treatment complained of. And so children living in households with more than 2 children was a protected status for the purpose of Article 14. Analogous or relevantly similar situations, so that's the third element of your discrimination test. And they said what you really have to look at here is the aim of the measure. So are they analogous in respect of the aim? For example, there was no direct discrimination between children who benefited from child tax credit and adults who received other types of benefit, because their aims were different, and so they weren't analogous. SC also usefully reiterated the test for indirect discrimination, and also the fact that once the claimant has put forward a prima facie case of indirect discrimination, then the burden shifts to the government to either show it wasn't discriminatory or it was justified. And to that extent, well, to an extent, that departs from previous case law. For example, the Supreme Court case in DA indicated that when manifestly without reasonable foundation applies, then the claimant bears the burden of proving justification, but SC indicates that's wrong. So SC also came to some important conclusions about international law, but I know that Shushin and Aoife are going to deal with this in more detail, so I'll leave those to one side. And finally, just summarize the actual factual findings of the case, and this element of the case wasn't helpful. It found that the Supreme Court found that, firstly, there was no indirect discrimination between children and adults, and that's because the measure didn't affect them in comparable ways. So you have to have an ostensibly neutral measure that affects everyone on the face of it in comparable ways, and here it didn't. So no indirect discrimination. It was indirectly discriminatory against women. More women suffered the disadvantage of the 2-child limit. It was directly discriminatory against children in families with more than 2 children. That was the nature of the measure, but both of them were justified in the particular circumstances. So the second case I will deal with much quicker is AB, brought on behalf of a child in detention who was subject to solitary confinement. And the Supreme Court held solitary confinement of a child doesn't inevitably breach Article 3. Whether it does depends on a number of factors you'll probably be familiar with. For example, the impact of the solitary confinement, its duration, the age of the child, how vulnerable they were. And one has to look at all of those factors together to decide whether there was a breach of Article 3. Now, the important point about AB, I think, is that they certainly didn't say that solitary confinement won't breach Article 3. They simply said that it won't automatically breach it in every case. The other aspect of the case was it was argued that the approach that's applied under Article 3 to cases of violence should apply in solitary confinement cases. Now, violence can't be used under Article 3 on someone who's in detention unless it's strictly necessary. And it was argued that that should also apply to solitary confinement. So it can't be used unless it's strictly necessary. But the Supreme Court said no to that. Keelan Gallagher QC and Adam Wagner from Doughty Street appeared in that case. And I think Keelan may be attending, but it may be that we hear something from them later on that. I'm not sure about that. So that's a summary of those 2 cases. With that in mind, I'll now pass over to Jamie to present his talk.
Thank you very much, Adam. Excellent introduction to the issues in these 2 important cases, as you say. By way of a small introduction on my part before my slides come up, I just thought I'd comment in this way, that on one view, both of these challenges were incredibly ambitious. I think it's important to remember that. In AB, they were seeking to establish, as Adam has pointed out, that solitary confinement automatically breaches Article 3 in a way that doesn't require any examination of the individual facts, or at the very least creates a sort of presumption that it probably does, unless there are exceptional circumstances or some established necessity. And that's an ambitious challenge, because that's not been the approach of the European Court to almost any of the rights contained in the Convention, and certainly not Article 3, which has a certain preserved status in order to retain its authority as an unqualified right of particular importance. And moreover, the arguments, at least those arguments put forward on behalf of the appellant in AB, were almost exclusively based on the UNCRC as the platform from which the proposition that solitary confinement would always be in breach of Article 3 was based. And as we'll come on to see during this seminar, the court's attitude to unincorporated international conventions, whether they be human rights-based ones or not, is fairly predictable and not entirely out of line, in my view, with the previous pronouncements of the court. So in many respects, the decision ultimately at the Supreme Court level in AB is perhaps not that surprising. Similarly, in SC, I think it's important to recognize that there again, you had a challenge to primary legislation, which had passed through Parliament on the premise that this was a necessary reform pursuant to the government's manifesto. And it had been extensively debated in Parliament, and indeed, as we'll come on to see, the claimants in that case, as solicitors, and I'll come back to that point in a minute, participated in that parliamentary process in the form of briefings, etc. And in terms of substantive challenges, in SC at least, it was always, one might think, ambitious to suggest that through Article 8 or Article 12, which is the right to maintain a family, there could be a sort of substantive right to subsistence for a third child. Now, the arguments were put in a different way in SC. There was a focus on the obvious, and one would say it's obvious, implications of a rule that limited the subsistence payments to only the first two children, which is that it would influence the decisions of parents in relation to how many children they might have in a way which might be said to breach Article 3. But the substantive challenges were obviously going to be difficult in circumstances where we have no substantive right to social security, either as a child or as an adult. But why these cases are, if you like, so shocking to us in particular who practice in this area is because of what they actually entail in substantive terms. You know, the idea that a 15-year-old can be subjected to segregation of this kind it morally appears to us to be highly questionable. And it's right to ask the question, isn't it obviously a breach of human rights in those circumstances? And similarly in SC, the contention that the social security system should limit the number of children that families can have, or limit the subsistence payments that are available for low-income families simply because of the number of children that they have, is shocking. And therefore, it's that combination, it seems to me, that has produced these two decisions. Very ambitious legal challenges in circumstances where the underlying policy or decision offends what many of us consider to be the rights of children in particular. Nevertheless, having said all that, I'm going to try and say a few things about what's good about SC, what's bad about it, and what's ugly about it. And I am at various points trying to sort of gild the lily a bit and see whether or not it's really as bad as it all seems. Ray, would you mind moving on the slides? So the good, as Adam has already explained, effectively the position in relation to the manifestly without reasonable foundation test has now been changed. I put Lord Wilson's quote there in DA, which is of course only a decision of a couple of years ago, where this argument about whether or not manifestly was the correct test in the context of challenges concerning welfare benefits was raised again, and Lord Wilson confirmed that it was the correct test and finished paragraph 65 with the now infamous words, "Let there be no future doubt about it." Of course, there was doubt about it, cast almost immediately by the European Court of Human Rights in JD versus the United Kingdom, who said, well, it's only available in cases which concern transitional measures designed to reverse previous historic disadvantage. So, for example, where you might be trying to reverse disadvantage caused to women in relation to pension payments, etc. Ray, could we move on, please? The submission in SC was that complaints of discrimination on suspect grounds fall outside the scope of the wide margin and manifestly without reasonable foundation approach usually accorded in the field of welfare benefits, unless the case concerns transitional measures. So that was the submission. And Lord Reid's contrary analysis of the European Court case law led him to this summary. The recent cases indicate the general need for strict scrutiny, focused on the requirement for very weighty reasons, where the difference in treatment is based on the suspect ground, unless the issue concerns the timing of reform designed to address historical inequalities, where a wide margin is likely to be appropriate. And you can see quite quickly there, forensically, there isn't a huge amount of difference between those two end scenarios. Ray, could we move on, please? And then ultimately we see the conclusion, and Adam's already explained that the imposition of the manifesto without reasonable foundation test in matters of social economic policy as a sort of binary test was wrong, and Humphreys was wrong to say so. There should be a flexible test in the manner that Adam described. And in making those conclusions, Lord Reid also made some other useful comments, it seems to me, about suspect grounds and weighty reasons, and I've listed two of those there that are perhaps helpful. First is that the list of suspect grounds is not closed, and that new ones can be added. And the test is really about whether or not you're dealing with something which is about stereotyping, stigma, and social exclusion, which prevent participation in society on an equal footing to others. And you can see quite quickly that there are a number of grounds that might fit within that. And indeed, in SC, it's confirmed that disability would fit within that definition. The second part, I think, is really important in terms of clarity in the law, that the weighty reasons approach applies whether or not the discrimination is direct or indirect. But you can tell Lord Reid is reaching that conclusion really through gritted teeth. He does it with very considerable reluctance, in my view. And then he says, you know, this is the kind of, as it were, the hand that gives and then the hand that takes away. He says the degree of deference usually appropriate in relation to social economic policy choices may have to be taken into account in assessing whether very weighty reasons have been shown. And that does seem to me to take us sort of back to square one to some extent, because how does one then marry those two competing considerations? The degree of deference necessary in social economic cases and the concept of very weighty reasons. Ray, can we move on, please? So what's bad? Well, effectively, what's definitely bad, if I can put it that way, is insofar as it was ever in doubt, as Supreme Court have now unequivocally confirmed, that it's not open to the domestic courts to determine whether or not the government is in compliance with its international human rights obligations insofar as they arise from unincorporated treaties. And it was, in fact, an agreed issue in this case. Ray, if we could move on to the next slide, thank you. An issue agreed between the parties in the Statement of Facts and Issues was whether or not the UK's obligations under the UNCRC had been breached in the present case, and if so, whether in the circumstances the two-child limit is compatible with convention rights. And effectively what Lord Reid said is that that's just the wrong approach, and the question just didn't call for determination, because we live in a dualist legal system, as we know. And because of parliamentary sovereignty, that means the government's actions on the international plane cannot add to the stock of rights that we enjoy as citizens, and indeed, of course, cannot take away from our rights. And as Adam has already pointed out, this, to some extent, was a moving away from the position established in previous cases, in previous Supreme Court cases, and it's the two benefit cap cases in particular, SG and DA, and then Matheson, which are most in the firing line in that regard. And moreover, on the general piece in AB, Lord Reid again giving a unanimous decision or judgment agreed by all the 5 justices in that case, commented on general comments and said, in particular, that they are not indeed authoritative, as they'd previously been described by both Lord Carnworth in SG and Lord Wilson in Mafferton, or even particularly useful. And Lord Reid spent some time, and to be fair, nobody in the Supreme Court or anywhere else has really spent the time to do this so far, establishing what general comments are and where they've come from. As he says, they have no defined status. They're not analogous to the rulings of an international court, and it's difficult to disagree with either of those observations. And then in particular in relation to the UNCRC, so that's a Committee on the Rights of the Child, Lord Reid went this far. He said it's not a judicial body. Well, again, nobody would suggest it is. It's certainly quasi-judicial, however. Its members represent a variety of professional backgrounds. The members initially elected, for example, included persons with backgrounds in social work, medicine, journalism, governmental, non-governmental work, juvenile justice, human rights, and international law. He doesn't update that description of the level of expertise at the CRC. And it's hard not to read some of Lord Reid's comments in both of these judgments as being slightly veiled attacks on what he considers to be not really proper law or proper lawyers. And I'll come back to that theme in a moment. But certainly when you put A, B and SC together, the picture looks pretty bleak when it comes to trying to rely upon international human rights law in unincorporated treaties to advance convention arguments domestically. Ray, could we move on, please? So just dealing quickly with Article 3, I think Xu Xin in particular is going to say something about this, so I'm only going to say very little, but Lord Reid had already set out his stall in Benefit Cap number 1, which some might say was a slight misunderstanding of what was really being proposed, which he said that if you did say that Article 3.1 of UNCRC, the best interest doctrine, applied, that would effectively supplant the manifesto without reasonable foundation test. And that's certainly not what was ultimately decided in Benefit Cap number 2 by Lord Wilson, where he said a decision not made in substantial compliance with Article 3.1 might well be manifestly unreasonable. So there certainly wasn't an automatic conclusion. It didn't follow inexorably from a finding that Article 3.1 had not been complied with, that the relevant provision was manifestly unreasonable and therefore incompatible with Article 14. Ray, could we move on, please? And then ultimately we see what the present position is as Lord Reid understands it, and it's paragraph 92. And he basically draws a distinction between saying that Secretary of State was under a duty to treat the best interests of children as a primary consideration before making the legislation. That is no longer the law, but there could be no objection to the following proposition, that the best interests of children are a relevant factor in the court's assessment of whether or not the differential treatment resulting from the legislation was justified. Now, what is potentially lost in this is the rigor around the process aspect of the best interest duty that comes from general comment number 14. And I've just included one quote there. And effectively what that general comment says is, look, first of all, you need to establish what the best interests are, and that has to be a sort of neutral objective exercise looking at the positives and the benefits. And then you need to be able to demonstrate certain procedural guarantees have been complied with. That includes kind of participation, etc. And then perhaps most relevantly in the recent case law, demonstrating the best interests have explicitly been taken into account. So it still remains sort of open where even on a kind of conventional understanding of best interest, we are in relation to those process obligations. How can you take the best interest into account if you don't determine what they are in the first place, for example? Ray, could we move on, please? And just to remind everybody quickly, in the Court of Appeal, it was made as a finding that the executive have given no consideration at all to the best interest of children. Parliament, however, did consider the best interest of children, but in the conclusion of the court, the two-child rule certainly wasn't in the best interest of the children affected. Now, when it came to how these arguments were panned out in the Supreme Court, we then start to move on to the ugly and the last part of my talk. Now, in light of those conclusions in the Court of Appeal, it might not be surprising to know that the appellant in its submissions in relation to proportionality relied very much on the government statements and documents, including the impact assessments and the statement of compatibility with EHRC, the European Convention, where it was said it was plain the executive, just as a Court of Appeal had found, simply hadn't looked at best interest properly at all, whereas the government wanted to rely on the material that had been placed before Parliament by other bodies as well as the government. And of course, that broader inquiry included all the submissions from people like Child Poverty Action Group and others who sought to oppose the policy. And the conclusion of the court, Ray, if we could pass over, is that the former, so that's government statements, were sort of effectively illegitimate insofar as it was supposed that those views could be transposed onto Parliament. They couldn't be. Parliament was a decision maker, and Parliament, of course, has no duty to explain or provide reasons for its decisions. And therefore it'd be illegitimate to say that any comments made by ministers or the executive generally were those of Parliament. However, the broader materials in the parliamentary debates could be looked at to an extent, but this is where matters get a little bit more difficult and nuanced. Lord Reid quoted Lord Nichols in the famous Wilson and First County case, or Lord Nichols' famous judgment in the Wilson and First County case, where he said lack of cogent justification in the course of parliamentary debate is not a matter which counts against the legislation on issues of proportionality. The court is called upon to evaluate the proportionality of the legislation, not the adequacy of the minister's exploration of the policy options or his explanations to Parliament. The latter would contravene Article 9 of the Bill of Rights. So there is clear endorsement of the principle that it's not open to the courts to evaluate whether or not particular legislation is compatible based on the quality of the debates in Parliament. Ray, could we move to the next slide? Thank you. So what's the conclusion in SC? Well, it's a bit lopsided. If it can be inferred that Parliament formed a judgment that the legislation was appropriate, notwithstanding its potential impact upon interests protected by conventional rights, then that may be a relevant factor in the court's assessment. And indeed, that's precisely what the court went on to find in the context of the two-child rule, because of the respect which the court will accord to the views of the legislature. If, on the other hand, there is no indication that the issue was considered by Parliament, then that factor will be absent. That absence will not count against upholding the compatibility of the measure. Now, that's really contrary to the general thrust of many authorities, principally from the Court of Appeal, but also the Supreme Court, where it was said that the absence of any consideration certainly would be a factor that would point towards a lack of justification. Ray, I think you went back 2 slides there, sorry. Could you move on one, please? And again, please, thanks. And back one. So, effectively, so the absence of any consideration by Parliament will be a neutral consideration, and then it'll be for the court to make up its own mind. But then with that sort of, I would suggest, quite illuminating caveat at the end, but nevertheless paying appropriate respect to the will of Parliament as expressed in the legislation. I mean, what does that mean? And one can see how the government is going to raise that repeatedly in cases going on in the future, as it will with the remaining parts of my analysis of the ugly. Ray, if we could pass on, please. So there is no doubt at all, it seems to me, that Lord Reid took the view that there is something inherently dangerous, either from the court's perspective or from society's perspective, in allowing campaigning organisations, as he described them, to support legal challenges, either by working as their solicitors for the clients or otherwise, in order to try and, if you like, refight the battles they've already lost at the parliamentary level. And he says it's the combination of that type of practice, which he says is growing, and the broad discretion available when one is considering justification in the context of Article 40, that creates the risk of interference by the courts in the sphere of political choices. It says that risk can only be avoided if the courts apply the principle in a manner which respects the boundaries between legality and the political process. And then he quotes the minority judges in SD in order to support that proposition. And it does seem to me that's where the potential chill in SC at least lies, that you can see this is going to be quoted all over the place by the government. They're going to say very repeatedly that every challenge is now simply a politically motivated one, and therefore should be looked at with considerable circumspection by the courts. And of course, many judges, particularly judges perhaps in the High Court, will take that to heart and will be concerned that they're not endorsing politically motivated litigation. And alongside a couple of other comments, which I haven't really focused upon, but I'll just very quickly mention, where Lord Reid sort of elides the concept of rationality and justification under Article 14. There is a real danger, it seems to me, that we are going to lose sight of the difference between a piece of political advocacy by an organisation like CPAG or another, which has different departments and different personnel dealing with, on the one hand, how to advocate in the political domain, and the equally well qualified lawyers who are arguing the points on established principles of law in relation to discrimination. Because the bottom line is this: ultimately it may be for Parliament to legislate, and obviously it's ultimately for Parliament to satisfy itself that legislation achieves the correct balance. But discrimination is a different discipline that requires application of completely different principles and a completely different type of intellectual rigour that is not available in Parliament and is indeed only available in our courts. And Lord Reid, it seems to me, is at risk, at least, if he hasn't done it himself, of allowing others to believe that there is in fact no true distinction between, on the one hand, a political lobbying exercise designed to demonstrate that a piece of legislation is unwise, and a piece of legal accuracy which seeks to understand and demonstrate that a piece of legislation is unjustified, in particular in light of its impact on those who are, share protected characteristics or otherwise suspect grounds. So that seems to me to be where the danger in these judgments, in particular SC, lies. Whereas if you actually look at where the court moved the dial on some of these key issues, it's perhaps not quite as bad as we first thought. Okay, Ray, thanks very much.
Thanks very much, Jamie. Your version, I think, was even better than Clint Eastwood's. I'll now hand over to Shushin for the next talk.
Thank you, Adam. Adam and Jamie have already looked at the Supreme Court's most recent judgments in some detail. I think when the judgments came out, and one of the reasons that prompted this seminar was that there was a lot said in there that suggested that they represented a regression in child rights. And so what I wanted to do in preparation for today was to step back and look at how we got here. Because it's been 30 years since the UK has ratified the UNCRC and 32 years since the convention came into force. And the UK was a key proponent of the convention and had said at the time, the government of the day had said at the time of ratification and consistently thereafter, that there was actually no need to incorporate unless there was any concern of non-compliance. What I would suggest actually is that perhaps when looking back at the case law, that we haven't really gone as far as we thought we had in the use of the UNCRC in domestic law, and certainly not much beyond the well-known provision under Article 3.1 on the requirement to have the child's best interest as a primary consideration. Earlier cases such as Venables and the Howard Lee case established that the UNCRC as a convention can be properly consulted to reaffirm, elucidate the nature and scope of rights guaranteed under the ECHR. This has largely remained the approach taken by the court since then. And so one may think, therefore, that the approach of the Supreme Court in their recent judgments on the relationship between the UNCRC and domestic law are not all that inconsistent with this and not all that surprising. But the main difference, I would suggest, is that the case law and the tenor of the court judgments over the years evolved in such a way that the UNCRC had become an indispensable tool in elucidating the scope and nature, not only of rights guaranteed under the ECHR, but also domestic law. The important implication of this was that it actually elevated children to a position as a rights holder rather than a passive participant subservient to the rights of adults on whom in many circumstances they depend. And you can see this from the case of ZH Tanzania, which was really about a deportation of a mother. And the decision-making of the Secretary of State was all about deportation and removal of the mother who had a poor criminal history and immigration history. But the Supreme Court in that case said, you must consider the impact on the child independently as a rights holder and consider the proportionality vis-a-vis the child as to the impact suffered by her mother's deportation. Lord Kerr's oft-cited passage on the hierarchy of consideration of child's best interest being a primary consideration and it's sitting on top of that, bears remembering. Similarly, in HH, a case on extradition, which would force the separation of a parent and from the child, also shed a light on the focus needing to be on the position of the child separate to the parent. Recognition of best interest as a foundational cornerstone of child rights approach was applied more overtly to the interpretation of domestic legislation in the case of Zolomeso. That was a case that actually didn't involve Article 8 of the ECHR, but rather the welfare duty under Section 11 of the Children Act 2004. There, Lady Hale posited the possibility that domestic legislation as it stands, without using the vehicle of the ECHR, should also itself be construed consistently with the UK's international obligations under Article 3 of the UNCRC, so that the rather patriarchal concept of welfare has to be looked at in a rights-based best interests approach. And in that context, indeed, taking that kind of approach, the court concluded that the local authorities finding that a family was intentionally homeless because they refused to go to temporary housing far away from any support network failed to put the child's best interests at heart and consider independently the impact on the child rather than the mother who was the applicant in the homelessness application. But in reality, the development of this case law just mentioned really concentrates on one key aspect of best interest, the procedural aspect, that at the very least, the decision maker has to think about the best interest of the child as a primary consideration. That, however, as we all know, is just a fraction of what the UNCRC guarantees for children. And so in that context, the case of DA on the benefit cap may have been thought of as a significant leap forward because the court found in the context of a challenge to the cap on benefits discriminating against lone parents with young children, that if the state failed to treat the affected children's best interests as a primary consideration, such a breach may render a policy or rule discriminatory without justification. But the analysis of whether or not there was a breach in that context was rather disappointing because it rather accepted that passing reference by the government to the possible impact generally on children sufficed to demonstrate proper and engaged consideration of the child's position as a rights holder without more. Although Article 26, the right to benefit from Social Security, and Article 27, the right to a standard of living, was cited in Lord Wilson's judgment, it didn't really feature in the analysis and consideration of what a consideration of a child's best interest and a breach of Article 3 might look like or might require the decision maker to do. Surely a consideration of best interest is not an arid exercise devoid of an understanding of substantive rights that the child might have. But given that being the approach to the relevance of Article 3, perhaps the judgment in SE is less surprising. In a recent case of Moore, the Court of Appeal was equally dismissive of the relevance of the UNCRC and the child's position as a rights holder, where a rule of calculating the level of universal credit treated women on maternity allowance differently to women on statutory maternity pay, the effect of which meant that the award of universal credit could be reduced to nil for those on maternity allowance, leaving certain new mothers without any basic benefit at a time when they're on maternity leave and unable to work and looking after a newborn child. The High Court and the Court of Appeal's approach were, in essence, what's this got to do with the best interests of the child? The benefit claimed is that of the mothers, and the UNCRC doesn't give mothers with babies more rights, nor can Article 3.1 require that. But I would say that that's rather missing the point, and missing the point that in failing to consider the substantive rights and protections under the convention that inform what a child's best interest is, that affected the way in which the court analyzes the relevance of the UNCRC. And I would suggest that divorcing Article 3.1 from other rights under the UNCRC is really the problem to date. It makes it all too easy or tempting when the tide at the judiciary changes to sideline the UNCRC, in particular in the context of socio-economic rights. If anything, this review makes me think that the state of the law as it stands makes for a really strong case for incorporation of the UNCRC into domestic law. But obviously that's a wait and see situation, considering Scotland's attempt to do so is subject to consideration by the Supreme Court with judgment reserved. Thank you very much.
Thank you, Shushin. And finally, I'll pass on to Aoife for the last talk.
Okay, let me just try to share my screen and not close everything down. Okay, Ray, perhaps you could either make me a co-host or you could share the screen, share the slides. They should be with you now. Okay. Okay. Right. Here we go. Thanks very much, Ray. That's wonderful. Okay, so let's start here now. So obviously I'm conscious that it's 1:45. There's a lot of experts in the room. We've heard a lot, and some of what I say is going to piggyback on what others have said. So I'm not going to spend a massive amount of time on general background stuff. I think we've had superb overviews of the cases from Adam. I think what I want to point out as I begin is my comments are largely going to focus on the SC case. If you could change the slide, Ray, that would be fantastic. And so what I think is interesting about this case is we see, as Adam notes, this was a 7-judge case. And this was a 7-judge decision in a situation in which not one judge at the Court of Appeal or the High Court levels had found for the appellants. So there was clearly a very deliberate, I would argue, very deliberate effort to send a strong message. And I think in particular, the use of the 3 important preliminary questions makes clear what those messages were. And I think they've been explored extremely well by Jamie, Adam and Shu Shin. But I think I would underline the message that each of them made, that what the SC decision does is it gives a clear signal of a future judicial approach. And again, this is a child rights decision, but like the AB decision, and I think Jamie covered that very well, talking about the position of the 15-year-old detained child in that case, it is a child rights judgment that engages very little with the lived experience and real life impacts of the policy in question on the child. Okay, and so that's interesting. It's very much about decision-making processes. It's very formalist, it's very technical, it's procedural, but there's very little about the children themselves. So, and that is something, and another thing that is obviously extremely important is the fact that it is a decision that accords primacy in effect to the legislative outputs of democratic decision-making processes. And in effect, it is very challenging, particularly in the area of social and economic policy, to envisage a situation, I think, at this point where the courts will really interrogate the outputs of democratic decision-making processes that have in fact complied with the procedural requirements. Okay, and I want to interrogate this point a little bit in my following comments. Ray, if you could change the slide, please. So, first of all, I think it's very important. I want to start with this primacy of democracy point, and this will be my key focus in my comments. At paragraph 208, as Jamie has already flagged, we see a statement from the court that the assessment of proportionality therefore ultimately resolves itself into the question as to whether Parliament made the right judgment. This was at the time and remains a question of intense political controversy. Okay. The court then says there are no legal standards by which a court can decide where the balance should be struck between the interests of children and their parents in receiving support from the state on the one hand, and the interests of the community as a whole in placing responsibility for the care of children upon their parents on the other. Now, this may well be open to debate, but in the court's view, crucially, the answer to this question could only be determined in a parliamentary democracy through, and as you can see, I'm quoting, a political process which can take account of the values and views of all sections of society. Democratically elected institutions are in a far better position than the courts to reflect a collective sense of what is fair and affordable, or of where the balance of fairness lies. Now, I want to flag that, in particular, a political process which can take account of the values and views of all sections of society. Ray, if you could move on to the next slide, that would be extremely helpful. And in this case, the court found that the democratic credentials of the measure couldn't be stronger. They go through the various processes, and it's done in some detail in the judgment. And the court concludes that there is no basis consistent with the separation of powers under our constitution on which the courts could properly overturn Parliament's judgment that the measure was an appropriate means of achieving its aims. Next slide, please. So what we see here is we see great democratic credentials. So where does this leave children, right? And these are cases that are enormously important from the perspective of children and children's rights. So obviously it's trite to say children aren't directly represented in democratic decision-making. They don't, certainly in England and Wales, they do not sorry, in England, they do not vote. People under 18 do not have the right to vote. So first of all, that brings us back to the court statement. Here we have a section of society whose values and views are not taken into account in the democratic decision-making processes, to which the court has basically said, has said, well, these are the processes by which the rights issues in question will be disposed of. Okay, so we see immediately an inconsistency with how the court sees democratic decision-making, and it's kind of manifestation of values, all the values and views of all of society, and what actually happens in practice. And we could move on from there and we could say, oh, well, it doesn't matter. I mean, maybe children don't vote, but after all, you know, they've parents, they've adults. But the fact is, at this point, it is very clearly established through, you know, and academic research has played a role here, but of course, work, you know, and work by think tanks, etc. But that actually, it's not just about kids not being able to vote. There is, in fact, a major problem when it comes to giving effect to children's views and values, again, quoting the court, on the basis of kind of a Burkean notion of virtual representation of children by other groups, right? And this is generally understood to happen on the basis of shared interests, sympathy or empathy. I have very limited time here. I can come back to it later, but it is very clear that there are situations in which adults and children do not have shared interests, whether it's parents and children or adults and children more widely. There are groups of children for whom there are not high levels of sympathy. I'm thinking about the kid in AB with his racist, sexually violent record. And empathy, again, challenges there. And of course, what we have in the UK as well is it's not just that we also have the exacerbation of demographic factors, right? We have older people vote more. Older people are less likely to vote for issues that are of huge concern for young children. I'm thinking things like, you know, climate justice, etc. So that's kind of a sub-element of the issue that here in the UK, in particular, there are concerns about the extent to which democratic decision-making represents the values and views of children who are affected by the outputs of that democratic decision-making. Now, this may sound incredibly abstract, right? And all very academic and, oh, how wonderful we're talking about children and where they are, blah, blah, blah. But actually, this is really important, this social, political, economic position of children, because it brings us back to the judicial role, okay? And if the court is going to accord primacy to democratic decision-making processes and laud the democratic credentials of a particular piece of legislation, there is a need for those appearing before the court to push for the court to acknowledge the implications of children's position for key constitutional principles such as the counter-majoritarian difficulty and also the traditional construal of the separation of powers, right? Here we see, you know, very limited role for the courts, very broad discretion accorded to democratic decision makers. Is this appropriate in cases involving children? And the fact is, it can be argued very strongly, and there are other courts in different places that have taken the approach that there is a need for greater attention and scrutiny when it comes to judicial assessment of the child rights impacts of democratic decision-making outputs. And in this case, for example, there was an argument for a more extensive engagement with best interests in the assessment of proportionality. So what I'm not suggesting is that barristers should go in and say, children don't vote, please abandon, you know, parliamentary, you know, your commitment to democratic decision-making and, you know, parliamentary supremacy or whatever. What I'm saying is it's about bringing it in a certain level and saying, well, actually, when you're dealing with this particular group, there is the courts have a particularly important role, and this is part of the judicial role under the separation of powers. And certain, you know, challenges such as the assumptions around counter-majoritarianism of judicial review have to be viewed in a different light when we're dealing with children. Next slide, please, Ray. I also want to flag this point that Jamie made, and I absolutely agree with his point about the chilling effect of this statement about basically law as politics as other means, right? We've heard it before. We will certainly, as Jamie says, hear it again. I think it's extremely important to note here, however, that when we're dealing with children, you have a situation in which litigation is particularly important. And again, this goes back to the issue of children's lack of ability to exercise direct and indirect power on political decision-making processes. So this statement is particularly concerning from the perspective of children's rights, because simply the avenues open to other advocacy or lobby groups or campaigning organizations, as the court calls them, simply aren't available to children. And the court makes no reference to this in their decision-making, and I suspect paid it very little attention. So for me, this is particularly concerning because this dicta really, this statement is profoundly concerning because it suggests that the door may be closing on an avenue for children that is particularly important and more important for them than for other groups in society who are represented in democracy. Next slide, please. And I want to make a very final comment, and I think this is interesting. I don't think that we necessarily flagged it before, and this is, there's another very concerning issue from the potentially concerning issue when we think about how the courts engages with children. And in paragraph 62, we see there may be an issue as to the scope of the concept of indirect discrimination. Every case to date, the court says, in which the European Court has treated the concept as relevant has concerned a group sharing a common characteristic corresponding to a suspect ground of differential treatment. They do not include age. Without necessarily going so far, one might in any event question whether children considered as a whole constitute a group of the relevant kind. I do not, however, need to examine that point, which was not raised in argument. This is obviously worrying for those who might wish to make cases around age discrimination based on youth, and it's not something that we should ignore. Final slide, please, Ryan. So finally, where do we have to go with this? We need to interrogate assumptions around democratic decision-making and the inappropriateness of the primacy of such in childlike manners. We need to make arguments before the courts, making clear the social, economic and political position of children. And finally, we need to make clear that other courts, to the extent that the courts here in the UK are open to this, have regarded the lack of political voice as a ground for enhanced judicially enforced human rights protection for children as the basis for an enhanced judicial role. I leave it there. Sorry, Adam, I've gone over time, despite saying I'd be short.
Not at all. Thank you very much, Aoife, and to all of the speakers today. I've certainly found all the talks fascinating. I note that there aren't any questions that have come up in the chat, so we will finish. But just before we do, I found a couple of quotes which might help. I know that Jamie's got a question, so I'll turn over to him in a moment. But if as expected, the government's responses to your claim say, look, this is, let's quote SC and say, look, this is a matter for Parliament, not the courts, then you might quote Bayev against Russia, which said the court reiterates that it would be incompatible with the underlying values of the convention if the exercise of convention rights by a minority group were made conditional on its being accepted by the majority. And you might quote In Re G, the unmarried couples legislation, where adoption was not available for those unmarried couples, which said the protection of minorities and discrimination in an area of social policy are a matter for the constitutional responsibility of the courts. I note that Jamie has a question. Jamie, would you like to come in and ask that?
Yes, thanks, Adam. I just couldn't resist, sorry. And it's to Aoife, because I really enjoyed Aoife's comments there. And as ever, with Aoife and academics more generally, you know, they give you a different perspective. But, you know, on this process obligation in Article 3.1, I mean, does that to some extent exist in order to make up for the, if you like, democratic deficits that flow from not having children properly represented in decision making? In other words, it's a poor substitute, but in circumstances where children themselves don't participate in the democratic decision making, at least the process of evaluating best interest objectively, you know, involving children, making sure they participate, making sure that you then treat them as a primary consideration. I mean, it seems to me that part of the purpose of that must be to make up for that deficiency. And if that's so, is the loss of Article 3 as a clear, you know, well-defined legal principle not really quite tragic in that context? I can see there's a question for me, Adam, as well, which I'll read whilst Eva tries to answer my terrible question.
I assume you're talking about Article 3.1.
I am, yes.
Yeah, so what I would say is Article 3.1 certainly is very useful in the UK because it's the way in which children's rights in the CRC has been brought in to the ECHR and analysis. But what I would say is that the process obligation such as is imposed in no way compensates or takes into account the variety of factors that should necessarily be taken into account with regards to the court's role when dealing with children's rights cases. And I think, for instance, you mentioned the issue of participation, but that's not part of Article 3.1. That's part of Article 12 and wasn't even raised here. Sorry, I sound dismissive, I'm not, but I just want to highlight that Article 3.1 for sure, what it does is it makes the court look at children, but it in no way compensates meaningfully for a proper analysis or taking into account of children's social, economic and political position and how that should shape the court's approach to democratic decision-making outputs.
Great. Adam, can I answer Gabrielle's question?
Of course.
Thanks. I mean, I'm partly keen to answer this because I unequivocally think it is. Can everybody see Gabrielle's question, or does it need to be read out?
Might help if I just briefly summarise which is Lord Reid essentially radically departed from the views of a number of previous judges. Is this the final word, or is it just a view of one current member of the Supreme Court or the current composition of the Supreme Court, and we can see matters developing further once they leave?
I think the first point is it's certainly consistent with Lord Reid's previous pronouncements. But with respect to Lord Reid, I sometimes think he creates a bit of a straw man around CRC and international conventions, overstates their importance only to then take it away. What's interesting for me is that I actually applied to intervene on SC in order to make arguments on behalf of two charities, one which was an academic institution, about the meaning and effect of UN Article 3.1 in particular. And all the other parties agreed, including the Secretary of State. And the Supreme Court nevertheless refused us permission. I mean, there was no issue about time. There was no obvious reason why we should be refused permission. It was a completely routine application to intervene. So I chose to watch the hearing. And it seemed to me that Lord Reid and one other judge in particular had already decided that this was going to be the case, where they corrected, as they saw it, this trajectory that had been set in motion by some of their previous colleagues who were no longer sitting in the Supreme Court. And it is noticeable that the composition is so different from those previous cases. And so I don't think there's any coincidence, and I don't think anything that could have been said by the advocates on behalf of SC would have made a blind bit of difference. I mean, I watched the whole case was really about what was the relevance of the fact that the executive hadn't considered Article 3.1 and Parliament was deemed to have done so. And that's where all the argument lay. And of course, in one paragraph, Lord Reid says, well, the question's bogus. We don't need to answer that question at all. And then proceeds to deal with a whole host of other issues that were to some extent dealt with within the proceedings, but not necessarily as fully as the judgment might suggest. And I know Carla's listening to this. I don't know if she's still there, but I wonder if she has any comments about that, because it does seem to me that this was a position previously fixed by at least some of the judges, and ultimately they were obviously able to persuade all of them to agree with them. Whether that means there will be that case indefinitely, I don't know, but at least one of the two judges I'm referring to is particularly young. And Lord Reid is now the president for a while, so I think we could be in some difficulties for a while. Gabrielle, your speculation is entirely accurate. Well,
thank you, everyone. It's just past 2, so we'll end the seminar there, but thank you very much, everyone, for attending.
Thank you.